Oh my God, let's see anything.
Were you done with Feliciano?
Yes, I believe so.
Okay.
Thank you. Okay. Now calling 25S00289. This is the state of Michigan versus Daniel Ryan Magoo. Mr. Magoo, can you state your name for the record, please?
Daniel Magoo.
Okay. Before we get started, will you be accepting Attorney Moton's representation for the purposes of this arraignment?
Yes.
Okay. So I am going to do this in a slightly different order than I usually do. You do have the right to remain silent. Anything that you say out loud or in writing can be used against you in court. You have the right to be presumed innocent beyond a reasonable doubt. You have the right to a trial by judge or by jury. You have the right to be represented by an attorney during all stages of these court proceedings, that is before, during, and after trial. If you cannot afford an attorney, one can be appointed to you. And again, we do have Attorney Moton here who can represent you at least for the purposes of this arraignment. Lastly, you are not required to disclose citizenship status to the court, but you do have the right to consult with an attorney to see if this case would have any effect on your citizenship status. If that last part doesn't apply to you, then you don't need to worry about it. So, do you have any questions about your rights?
Who would I talk to about my citizen status?
An attorney. So you can talk to Attorney Moton about it, or you can retain counsel.
Okay.
Okay, thank you. Now, we are here today for an arraignment on the following. What I have is a misdemeanor complaint. So this is alleging that you would stand accused of the following offenses that occurred in Ypsilanti Township on or about or between the dates of February 15th, 2025 through June 23rd, 2025. The location being 6988 McKean, Lot 72. Count 1, charges that you did maliciously use a service provided by a telecommunications service provider with the intent to terrorize, frighten, intimidate, threaten, harass, molest, annoy, or disturb the peace and quiet of Alyssa McClaskey, an individual with whom you have a child in common, by using any vulgar, indecent, obscene, or offensive language, or suggesting any lewd or lascivious act in the course of a conversation or message through the use of a telecommunications service or device. This is, again, a misdemeanor. It has a maximum penalty of up to 6 months in jail, a $1,000 fine plus court costs, or both the jail time and the fine. Count 2, charges that you did maliciously use a service provided by a telecommunications service provider with the intent to terrorize, frighten, intimidate, threaten, harass, molest, annoy, or disturb the peace and quiet of Scott McClaskey by using any vulgar, indecent, obscene, or offensive language, or suggesting any lewd or lascivious act in the course of a conversation or message through the use of a telecommunications service or device. Again, this is known as malicious use of a telecommunications service. It is a misdemeanor with a maximum penalty of up to 6 months in jail, a $1,000 fine plus court costs, or both the jail time and the fine. So, you understand that you are currently standing accused of 2 separate counts of malicious use of telecommunication services.
Yes.
Okay, thank you. So, Attorney Moton, do you want to address the plea and the bond?
Yes, Ashley Moton on behalf of Mr. Magoo, who will stand mute to the charges. Mr. Magoo presents himself today in a much better space than he was last week. We discussed the bond conditions. He has no issues with any of them. I did see on the prosecutor's bond form, they're asking for a monetary bond and a tether. I believe both is pretty excessive for this charge. he hasn't had any issues, or there haven't been any reports about having any contact or physical contact with either of these complaining witnesses. There are pending civil cases for false police reports regarding these matters. He is in custody until at least until the 17th for other pending charges. We are requesting a nominal bond so he can get jail credit that will convert to a personal bond if he is released on those other cases. If the court finds that a tether is necessary, then we understand that. But however, I believe both is pretty excessive. So we are requesting either the tether or a nominal bond that'll convert to a personal bond. Thank you.
Okay. Thank you. The court will set a pretrial conference date that will be July 21st, 2025. That will be at 9 in the morning over Zoom in front of Judge Washington. The court will set bond with the following conditions. You are not to use or possess alcohol, marijuana, or illegal drugs. You are not to purchase or possess any firearms, ammunition, other dangerous weapons, or the means to create them. Any weapons that you do possess are to be surrendered. You are not to leave the state of Michigan without the court's permission. Within 24 hours of your release, you are to report to community corrections for drug and alcohol testing. You will need $12 and a photo ID. You are not to have contact with Alyssa McClaskey or Scott McClaskey. When the court says no contact, what the court means is the following. You are not to have in-person contact, no contact through the mail, no contact over the computer or phone or other telecommunications service or device via phone calls, text messages, emails, social media, the internet in any way, shape, or form, or through third parties. You are not to go to that McKean address. When the court says do not go, the court does not care. If you own a place, rent a place, or are personally invited to go to a place, do not go. You are not to engage in any sort of assaultive, threatening, harassing, terrorizing, molesting, or stalking behaviors towards Alyssa McClaskey or Scott McClaskey or anyone else. You are not to engage in any sort of criminal activity whatsoever. You are to appear for any and all dates set for you by the court, the next one in this matter being that July 21st pretrial at 9 in the morning over Zoom. These conditions will be, that also means going to community corrections as directed. These conditions will be entered into the Law Enforcement Information Network. They will be readily accessible to any police officers that you may come into contact with. And if they have probable cause to believe that you have violated one of these conditions, they can arrest you on the spot and you'll be held for a bond violation hearing in front of a judge who may revoke your bond and set a new, more restrictive one. At this time, the court is going to set a $10,000 cash or surety bond. 10% is allowed. Mr. Magoo, do you have any questions about anything I've just said?
The bond meaning can I not be released until that bond is paid? Or is it if I violate, I have to? How's that work?
So at this time, it's a $10,000 bond. You can post $1,000 to be released. But my understanding is that there are other matters keeping you in custody at the moment.
So you're saying that if even if I cleared up all the other matters, unless I post $1,000 from the 10% of the 10,000, that I'm stuck in custody ultimately indefinitely, unless I post $1,000.
Currently, yes, that can be readdressed at your next court date, though, on the 21st.
That is really intangible. I would just really request a smaller bond being that there's pending civil cases against these people for malicious use of law enforcement and false reporting in federal court.
Thank you, Mr. Magoo. And I can appreciate that. I can also appreciate the that there was a bench warrant issued for failure to appear out of the 22nd Circuit Court. So bond is set for two reasons. One is to ensure your appearance at future court dates. All right. So at this time, bond is what it is. You can certainly request that it be modified either through a motion prior to your next court date or at the next court date. But your hearing is concluded at this point. You are free to go to the door and tell the jail that you are finished.
Thank you, Ashley.
All right, let's talk about that. This arraignment for Daniel Ryan Magoo had all the markings of a courtroom moment where everyone was trying to stay calm, follow the script, and not get lost in the tension or the tether requests. The hearing opened with Magistrate Hilary Braley laying out 2 misdemeanor charges for malicious use of a telecommunications device, one involving Alyssa McClaskey and the other Scott McClaskey. According to the complaint, the alleged conduct took place between February and June, and the content described included threats, harassment, and offensive language over some kind of digital communication. As usual, Magistrate Braley kept her tone steady and respectful while laying out the rights and charges, ensuring that Mr. Magoo understood exactly what he was facing. Now, here's where it got interesting. Public Defender Ashley Moton stepped in and did what a good defense attorney does. She argued for balance. She acknowledged the prosecutor's request for a monetary bond and a tether, but pushed back, noting that Mr. Magoo has had no physical contact with either of the named individuals. There were pending civil suits about the same matters, and most importantly, that he was already being held on unrelated charges. Moton's point, a tether and a cash bond on top of that, seemed like stacking penalties. She asked for either a nominal bond or the tether, not both. It was a reasoned approach, calm and professional. Mr. Magoo himself, surprisingly composed, did not dispute the charges, but focused instead on his ability to comply with court orders, if only he had the means. His main concern, the $10,000 bond with 10% allowed. He essentially trapped him in custody unless he could pay $1,000. He expressed himself clearly and without hostility, even describing the bond amount as really intangible. For someone representing himself pro se in that moment of pushback, he managed to keep it civil, even as he tried to inject some context about the civil suits he's filed in federal court related to the allegations. Magistrate Braley held her line firm but not dismissive. She explained that the bond was being set partly due to a bench warrant in a prior case, emphasizing that the bond served the purpose of ensuring future appearances. Still, she gave Mr. Magoo a path forward, saying that he could ask for a modification at his next court date or file a motion to revisit the bond before then. And in that, we see the quiet function of the court doing what it's supposed to: risk, enforce structure, and leave room for review. No raised voices, no drama, just two sides navigating the system. So, while this hearing didn't have fireworks, it did reflect a familiar tension in the legal system, balancing liberty with accountability, especially for defendants facing multiple matters across courts. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.